Welcome everyone to today's AHLA podcast, where I will be talking to Robert Salcido from Akin Gump about the False Claims Act, or the FCA, which we'll be using that term today, and key trends that we're seeing in the industry, in the healthcare industry. Robert recently published the 5th edition of the AHLA's False Claims Act and Healthcare Industry book. I have a copy of it right here with me. It's a great resource. Today's podcast is brought to you by the American Health Law Association's Fraud and Abuse Practice Group. I'm in my last year of chairing the practice group, and our mission is to help all of you stay informed about healthcare fraud and abuse and compliance issues. We're midway through another program year, and our vice chairs are doing a great job of developing some awesome content for our members. If you aren't a member yet, please check out the AHLA website and sign up now. Again, we'll be talking to Robert today, who just issued that 5th edition of the AHLA FCA book. It has some great information broken out by the history of the False Claims Act, discussing some substantive provisions of the FCA, how the FCA civil actions work with whistleblower actions and that, damages and penalties, some procedure and jurisdictional information, then some discussion about civil investigative demands and voluntary disclosure. So please check out that book. We might allude to it during the podcast here, but it's a really strong resource, and I recommend picking one up. And thanks again to Robert for participating. Before we get started, Robert, could you introduce yourself?
Yes, I'm Robert Salcido. I'm a partner at Akin, Gump, Strauss, Hauer, Feld for roughly 29 years. I was in the Washington, D.C. office. Now I work out of Southern California, Akin, Gump's Irvine and Los Angeles offices. I started my career as a trial attorney with the civil fraud section of the United States Department of Justice, which, as you know, has nationwide jurisdiction over the False Claims Act.
Great. Thanks, Robert. And again, I'm Joe Wolfe. I chair the American Health Law Association's Fraud and Abuse Practice Group. I'm a shareholder and healthcare practice group leader at Hauer, and we're a boutique national healthcare firm. I've been at Hauer for 15 years, actually as the end of the month here. And I've practiced nearly 20 years, focused exclusively on healthcare. And we're going to start off here. I want to give a high-level overview of the False Claims Act, and Robert can correct me if I misstep along the way here. But we're talking about the False Claims Act at a high level. What is the FCA? Many of you listening in or watching know of this. It has a long history. Enacted back in the mid-1800s, sometimes called the Lincoln Law, and it's used to target fraud involving federal contracts and programs, and it's used to enforce actions within the healthcare space. It allows suits directly by the government as well as by whistleblowers or relators on behalf of the government as well. It can lead to significant exposure because of the damage calculations and how it works. The False Claims Act calls for treble damages, so 3 times the total claims paid in many cases. There are statutory penalties, there are per claim penalties in excess of $20,000. And this actually creates a really challenging regulatory area because of the potential for these very large damage figures. When we look at the False Claims Act, there are some key elements. When you look at the framework of the False Claims Act, at its heart, it focuses on some key terms that any person who knowingly presents or causes to be presented a false or fraudulent claim for payment, or knowingly uses or causes to be made or used a false record or statement material to a false or fraudulent claim. And then lastly, anyone who knowingly conceals or knowingly improperly avoids or decreases an obligation to pay or transmit money or property to the government can be liable for a civil penalty under this framework. And in the healthcare space, there are some key terms that I think are important to focus on. Robert might discuss some of these later. But when we're analyzing False Claims Act potential liability, we're talking about the concept of a claim. And what is a claim? And a claim is a request for government money or property that is presented to an officer of the government. Presenting is submitting or requesting payment via a claim. And we might think of in the healthcare space, the filing of reimbursement like a CMS 1500. We also are thinking about causing to be presented a claim. So defendants are not required to file the claim with the government themselves. They can engage in conduct that causes another to file a false claim. Some other final key terms here are materiality, knowingly whether the party under that is alleged to have violated the False Claims Act acted knowingly, whether there was an actual obligation to pay, and we're talking the case of a reverse false claim, the retention of a known overpayment. Some other key concepts are falsity. Do we actually have falsity? And there's factual falsity and legal falsity. We can be talking about false certification as a potential area where something could be legally false. And one area of that, and we're talking about false certification, is express false certification. And that's where a person or entity submits a claim and expressly certifies compliance with a statute, regulation, or other legal requirement. And that goes back to the example when a CMS 1500 is submitted, there's a certification that the services were medically necessary. This is where we start to drift into a potential liability under Stark and Kickback, that when claims are submitted there, you are certifying that you've complied with applicable legal requirements as well under an implied False Claims Act theory. And so this is why the False Claims Act potential liability does get a bit complex because of that terminology I just went through rather quickly. And lastly, these False Claims Act cases can be brought, as I mentioned earlier, under a whistleblower action. So brought in the name of the government by a qui tam relator. Qui tam relators bring that case on behalf of the government. When we think of qui tam potential plaintiffs or relators, they're often insiders, including current or former employees, competitors, patients. There are professional relators, as some would call them. But these people have personal knowledge and specific information related to the claims, and then they must follow certain qui tam procedure to bring cases forward, where it initiates with a complaint filed under seal, followed by a government investigation while the case is under seal, and then the importance of an intervention decision by the government, where the government decides to proceeds with the action to intervene or to notify the court that it's going to decline that intervention, and then the whistleblower potentially could continue and bring that case on their own. And that, of course, impacts the amount that the whistleblower could actually be awarded under the action as well, depending on how that decision is handled. So again, a very rapid overview of some of the concepts related to the False Claims Act and how False Claims Act cases are alleged and carried forward. Robert's book does a really good job of working through those concepts and much more. But here we're hoping to talk about some of the more practical current trends and issues related to the False Claims Act and what we're seeing in the market. And so, Robert, I just provided a very high-level overview of the False Claims Act. In addition to some of those concepts, I know there's been widespread coverage of the district court opinion just a few weeks ago declaring the False Claims Act's qui tam provisions unconstitutional. Can you speak to and describe that issue and how that issue is likely to play out over the next couple of years, and also speak to any other areas you are seeing involving significant FCA developments in the market right now?
Yes, thank you very much, Joe. in terms of constitutionality, that has been a major development that, in fact, has only come to life with a court decision approximately 3 weeks ago. But the catalyst for that was a decision by the Supreme Court recently in U.S. ex rel. Polanski versus Executive Health Resources, where you had a concurrence by Justice Kavanaugh and Barrett that was also a dissenting opinion by Justice Thomas, all of whom mentioned that the court should at some point review whether the qui tam provisions of the False Claims Act conform with the Constitution. The underlying issue there, as we all learned in constitutional law and law school, relates to separations of power. And more specifically, can Congress privatize law enforcement? Can Congress provide relators with authority to bring and enforce the False Claims Act on behalf of the United States government and wield executive power, such as deciding whom to sue and what theories to pursue, even if those theories undermine executive branch policies in so doing. So there's two components that are frequently raised. One is the take care clause in Article 2, that the executive branch is to take care to enforce the law, not private individuals. And then the focus of the district court opinion roughly 3 weeks ago in Zafirov versus Florida Medical Associates related to the appointments clause. Relators are not appointed as part of the executive branch. So her ruling was, in essence, that the appointments clause of the Constitution, Article 2, had been breached, and in actions in which the government doesn't intervene, then those actions would be dismissed because the relator wasn't appropriately appointed pursuant to the Constitution. Now, the repercussion of that is that in just about every action, defendants are going to have to raise the constitutional issue, particularly in non-intervened cases, but potentially in intervened cases as well. One potential stumbling block is that, of course, previously, before the concurrence and dissent in Polanski, courts going back more than a couple decades ago had uniformly ruled that qui tam provisions are constitutional. You had the Ninth Circuit, Fifth Circuit, Second Circuit, all ruling that the qui tam provisions were in fact constitutional. Now that issue is going to be revisited. There's going to be significant briefing. It's going to make its way up to the appellate courts. And even on a practical example, I've seen cases now where, for example, defendants have moved to quash CIDs where the catalyst of the CID is an underlying qui tam action. And the defendants are saying that those actions have a impermissible basis in a sense that it stems from a relator wielding unconstitutional powers. So those are that's the constitutional issue. Very briefly, three other issues that are significant from a defense standpoint. One is the Supreme Court's recent case, U.S. ex rel. Shute versus SuperValue, which has to do with False Claims Act knowledge. And the important issue there is, of course, the Supreme Court reversed the decision of 6 circuit courts of appeals that it said that when defendants have a reasonable interpretation of ambiguous law and there's no official governmental guidance to warn them away from that interpretation, that they were not acting with False Claims Act scienter. Supreme Court said, no, you could have subjective knowledge even if the underlying statute or regulation is objectively ambiguous. The focus now will be, does that undermine the doctrine of objective falsehood in any way, or is that still an established doctrine for purposes of False Claims Act falsity? And what level of subjective knowledge is sufficient to trigger that defendants are acting with reckless disregard or deliberate ignorance under the False Claims Act? So that's one other issue that we're tracking in the case law. Another related to causation and kickbacks, particularly, is the circuit split that relates to whether plaintiff must show but for causation with respect to the anti-kickback statute. And of course, there we have decisions from the Eighth Circuit and U.S. Ex Rel. Carnes versus DS Medical and U.S. Ex Rel. Martin versus Hathaway in the Sixth Circuit that say that but for causation needs to be shown. And then the other issue that we're tracking has to do, of course, with False Claims Act falsity and the exercise of clinical judgment and the split that we have between U.S. Ex Rel. Brudding versus Care Alternatives in the Third Circuit and the United States versus ACERICare in the 11th Circuit, where, of course, ACERICare, using objective falsehood, says that if reasonable clinicians could disagree, then the underlying claim, by definition, could not be a false claim for purposes of the False Claims Act. And the Drudding case in the Third Circuit, which indicates that ultimately that would be a jury question to determine. Those are the issues where we're really watching the case law. From an enforcement perspective, Joe, what kind of trends are you seeing?
Yeah, thanks, Robert, and thanks for that that overview and the case, especially the case in Florida. I'm licensed in Florida and was intrigued by looking at that opinion. Yeah, when we look at the enforcement and maybe some noteworthy cases, looking at the data from the last couple of years, and we look at activity in this area, the numbers around False Claims Act settlements and judgments continue to be significant, and I think the DOJ continues to focus on healthcare. We see in 2022 there's around 2.2 billion in FCA settlements, and 2023 2.68 billion, and on just the healthcare related. From a healthcare related standpoint, we saw 1.7 billion in the healthcare space in 2022, and then 1.8 billion in 2023. So significant numbers involving healthcare. One interesting item we did see in some of this data is that in 2022, around 11% of those judgments were brought by whistleblowers and non-whistleblowers, and then in 2023, 13%. So there's an uptick in judgments related to cases that were non-qui tam related. So that's an interesting development. We'll keep our eyes on that. The cases that we're seeing in this space, in the healthcare space, have focused on pharma and testing, hospitals and health systems, healthcare and insurance, and we're seeing large cases involving physician groups as well. We're seeing an uptick in what we had anticipated. COVID related False Claims Act cases are on the rise, and I think we're going to continue to see that. Another trend is that managed care seems to be in the crosshairs of the government, as well as there was an HHS and OIG strategic plan back in August of 2023 that is focusing in on the reliance of Medicare funds on the Medicare Advantage program. Because of the significant size of the Medicare Advantage program, that we do believe the government is going to continue to focus on identifying and preventing fraud in managed care plans. There is a primary focus in that enforcement space on the accuracy of risk adjustment scores, and so that's an area we're keeping our eyes on as well. And then, of course, as Robert, as you alluded to, the recent case law developments and how our clients are reacting and responding to The recent holding in the Loper Bright case, and I think we'll be talking about that again in sort of this post Chevron world, and what that means for reliance on agency insight into regulations, and actually how regulations are issued and what that's going to mean for our clients. So those are some big developments we're seeing. More broadly, in my practice day to day, much of my work involves Stark and kickback compliance, especially related to compensation models and formulas more granularly. So we have seen an uptick in CIDs in that specific area. And I don't expect that to be slowing down anytime soon. So those are a couple of a few of the areas that I'm seeing, or we're focusing on, I'm seeing. And I think you're going to talk about it now, Robert. We're hearing so much about this recent Loper Bright decision and the overturning of the longstanding Chevron doctrine. How do you see the court's decision impacting the FCA and healthcare enforcement in the short and long term from your perspective?
Yeah, I don't think that Loper Bright will have a significant impact. In fact, historically, if you were to search the Chevron doctrine and False Claims Act, you would get very few hits. There's tens of thousands of published False Claims Act cases, and a paucity of decisions that invoke the Chevron doctrine in any way. On one level, you would think that the court's ruling in Loper Bright would be helpful in the sense that it questions agency authority and agency rulemaking in one important respect. However, on the flip side, you have the longstanding Supreme Court doctrine, Bryson versus United States, which says in essence that even if the law is wrong, or even if the law is unconstitutional, if you knowingly breach the law, the fact of the law's being invalid is not a defense ultimately. So it's not as though you could violate a law and then say the agency interpretation of that law is invalid, and therefore you get a get out of jail ticket. That has not been successful in terms of invoking that. So given the fact that you'll still be saddled with agency interpretations, if that is valid law and that is breached knowingly with respect to the False Claims Act elements, the government will probably still have a cause of action. In terms of your practice, Joe, with respect to, I know a good part of it is responding to civil investigative demands and bringing False Claims Act cases to resolution. What trends are you seeing in that area?
Yeah, and thanks, Robert. As I mentioned earlier, we're seeing an uptick in CIDs, and especially, I said, in my practice related to Stark and kickback compliance and financial arrangements with referral sources, uptick in that area. And I do think developing some and following best practices in response to a CID is something it's very important for healthcare organizations to be thinking about. I think some steps or some thoughts on that is, if you are issued a CID, do consider retaining counsel to deal directly with the Department of Justice. We want to be careful about making statements to the government outside of counsel. Try to maintain a close hold on the fact that CID has been received. If you lose sort of control of that information, the information that can cause a lot of confusion within an organization, and it should be handled carefully. You want to make sure you notify the head of your IT department to make sure that your network and your systems are being handled appropriately as part of your document preservation process. You want to develop a response strategy with your counsel. Work with counsel to reach out to and work with the Department of Justice, look at issuing a formal legal hold memorandum. You're going to have to work on the responsive materials. So these steps are all very important. Of course, conduct an appropriate internal investigation, remedy your compliance concerns, and make sure you're in a position where you can present that information to the Department of Justice appropriately. So I'm on the CID side. I think those steps can be very helpful. Also consider, the most important proactive steps you can take to try to avoid some of the False Claims Act liability we've been discussing is to develop a self-reporting strategy. And we, beyond working on CIDs, do help clients work through and assess and self-disclose their compliance situations as well. It's really important because you can diffuse compliance issues before they escalate further. You can initiate a thorough and probing internal investigation to fix the issues, and then take your concerns to the government in order to get a better resolution in that way. It shows your organization's commitment to doing the right thing. And through those, through that kind of an approach, you have some different pathways. The normal pathways we see are, a voluntary refund is one track that we support our clients with. The other is following the OIG's healthcare fraud self-disclosure protocol. The other is the CMS self-disclosure protocol. And a final track may be going to your local office of the Assistant U.S. Attorney. Of course, as we mentioned earlier, that the kind of exposure that is present under the False Claims Act is significant. And if you choose these other paths to try to resolve these potential compliance issues, the potential exposure just drops dramatically. In the case of the OIG self-disclosure protocol, you might be looking at a resolution of that liability within a year. And then the settlement tends to be around 1.5 times the amount of the overpayment, assuming the government agrees with your calculation. And on the Stark side, if you choose to bring some kind of self-disclosure through that, we're seeing some of the damages assessments. They're not published, but we've seen some data that says that the potential settlement amounts are roughly 2% of the potentially tainted referrals. And of course, in both cases, if you go the CMS route, you only get a Stark release. Usually, if you go the OIG route, you can get both an anti-kickback and Stark release. But it's important to work through that strategy, and it can be a very effective and proactive way that you can try to minimize and mitigate potential risk under the False Claims Act if you identify a potential compliance issue and then through your probing investigation determine that those paths make sense. So we're seeing an uptick in self-disclosures. We're seeing an uptick in CIDs as well in my practice. And so, Robert, as you look forward, what do you see as the potential enforcement priorities of the government and emerging hot topics from your perspective?
Yeah, in terms of emerging hot topics, this may be at this point blaming out, but the huge spike that we saw had to do with actions related to COVID relief, Paycheck Protection Program, CIDs, where clients got a huge number. And also a large number of investigations having to do with skilled nursing facilities and how they adhered to evolving COVID regulations during the pandemic. And over the previous couple of years, there's been a substantial amount of government investigations and civil investigative demands on that particular area, including that particular area. The other area where the government has recently been very aggressive is bringing Stark and kickback allegations and intervening in those actions. And one thing I would say to those out there doing business with physicians or health systems with physicians is continue to get fair market value opinions. Those things from a litigation perspective are golden. You have, of course, US Ex Rel Bingham versus HCA, which says that payments at fair market value do not constitute remuneration for purposes of the anti-kickback statute. It's also when you have jury instructions, as you do in the anti-kickback sector, that you have to know that your conduct is wrongful, and you have fair market value opinions saying that the remuneration is paid at fair market value. It will do a lot to foreclose viable False Claims Act actions on both the anti-kickback side and on the Stark side as well.
Great. Thanks, Robert. We've had a chance to talk through some hot topics. I was just wondering if you had any final remarks for our audience today.
Yes, and a lot will mimic what you said earlier, Joe, which is stay ahead in terms of monitoring compliance issues. I think that the one issue that clients continually need to be careful about, however, with respect to overpayment issues, is that historically clients, particularly those who are risk averse, would, if issues were close to the line, even if they involved conditions of what are known as conditions of participation rather than conditions of payment, if they found a regulatory breach, they would make disclosures to the government. One of the downsides of doing that, in light of the Supreme Court's decision in Escobar, is if one makes repayments, the government takes that and relators take that as a concession that the entity believed that the breach was material to the government's determination to pay and will use that against them in subsequent litigation. So it's one thing always to consider when one is making a disclosure in terms of whether it really constitutes an overpayment for purposes of the False Claims Act, or whether the breach is one where the government would not insist on retrospective repayment, but instead a corrective action plan or some other type of remedy. And if that's true, then it's probably not an overpayment due to the government. So that's one other issue to be sensitive to.
Great. Thanks, Robert, and thanks to everyone for listening in to today's podcast or watching it through the video podcast. We really enjoyed hearing from Robert. I encourage you again to go out and pick up the 5th edition of his False Claims Act book that was published through AHLA. Watch for our upcoming content from the Fraud and Abuse Practice Group. Not only will we have future podcasts that are in the pipeline, but we do have an upcoming webinar on the new value-based or the newer value-based enterprise rules and compliance matters related to that. If you are interested in becoming more involved in the Fraud and Abuse Practice Group, please reach out to me through LinkedIn, or you could email me at jwolfe@wholerender.com, and I'd love to find an opportunity for you to get involved in the future. Thanks again, Robert, for being part of today's podcast, and thanks everyone for listening in, and have a great day.
Thank you.